Hello, everyone, and welcome to this Federalist Society virtual event. My name is Marco J. Lloyd, and I'm Assistant Director of Practice Groups for the Federalist Society. Today, we're excited to host a Courthouse Steps preview webinar on First Choice Women's Resource Centers, Platkin, featuring Erin Hawley. Erin serves as Senior Counsel and Vice President of the Center for Life and Regulatory Practice at the Alliance Defending Freedom. Before joining ADF, Erin practiced appellate law at several firms in Washington, D.C. She also worked at the Department of Justice, serving as counsel to Attorney General Michael Mukasey. Erin has litigated extensively before the Supreme Court, as well as numerous federal appeals courts and state courts of last resort. Our moderator for today's discussion is Professor Teresa Stanton-Collette. Professor Collette is a professor at the University of St. Thomas School of Law, where she serves as director of the school's Pro-Life Center. A prolific scholar, Professor Collette has published numerous legal articles and co-authored books on professional responsibility and Catholic perspectives on American law. Notably, she also served on the Pontifical Council for the Family under Pope Benedict and Pope Francis. Professor Collette has represented government officials and medical groups in significant legal cases concerning abortion and parental rights for the U.S. Supreme Court and federal appellate courts. If you'd like to learn more about today's speakers, their full bios are available on our website, fedsoc.org. If you have a question at any point in today's program, please enter it into the Q&A function at the bottom of your Zoom window. We will do our best to answer as many as we can. Finally, I'll note that, as always, the Federalist Society takes no position on particular legal or public policy issues, and all expressions of opinion are those of the speakers. With that, Professor, thank you for joining us today, and the floor is yours.
Thank you, Marco. This is a really important case for lots of different reasons and has lots of interesting sort of both constitutional and procedural questions. Erin, why don't you give our listeners and viewers just a thumbnail sketch of the basic facts for us?
Absolutely. So I wanted to start today with our client. Her name is Amy Huber. Amy Huber runs First Choice Women's Resource Centers in New Jersey. It's a collection of 5 locations that serve women and their families. And Amy was actually in her dad's service. Her dad was a pastor. She was sitting in the pew, I think the front row, when she was 12 years old, and she heard her dad give a sermon on life. And she knew at that moment that she wanted to stand for women, to stand for unborn children. And again, today, she's the executive director of 5 pregnancy centers in New Jersey that are doing exactly that. These pregnancy centers don't charge. They offer free resources, free pregnancy testing, free ultrasounds, free material resources like car seats and baby clothes, those sorts of things to New Jersey women. They've served about 32,000 New Jersey women since they began. But this unfortunately put them in the crosshairs of ideological opponents of life. So New Jersey Attorney General Matthew Platkin has made no secret of his animosity toward pregnancy care centers. Upon assuming office, one of his first things was to establish what he called a reproductive rights task force that was aimed at furthering abortion. As part of this, he issued a consumer alert against pregnancy care centers. Again, it's sort of strange that public enemy number one is pregnancy centers who just try to help women when no one else is there. But to Attorney General Platkin, these centers deserve a consumer alert. He actually sent this alert to Planned Parenthood affiliates, got their input, and thanked them for their partnership on drafting this consumer alert against First Choice and other pregnancy centers in New Jersey. But it didn't stop there. He also signed an open letter with other attorneys general pledging to go after pregnancy centers. And he made good on that threat when he issued an invasive subpoena to First Choice. In that subpoena, he requested up to 10 years of internal information and documents. In addition, and this is really astounding, but he requested not only the names, but the contact information, the phone numbers, the addresses, and the present and past place of employment for all, or most, I should say, for most of First Choice's donors, something we think is absolutely protected by the Constitution.
But in this instance, didn't it's A, non-self-executing, and B, the trial court, I believe, declined to enforce until it was narrowed, and that you all are at least in negotiations or at the state level on how to narrow the subpoena. Is that correct?
So not exactly. So the Attorney General, I think it's 36, either 33 or 36 times, the Attorney General in his brief in opposition notes that this subpoena is non-self-executing. But that's really a red herring, and it isn't actually true. The statute provides that the failure to comply with the subpoena itself subjects first choice to penalties, including ultimately contempt. The subpoena itself warns that the failure to comply with the subpoena might subject first choice to contempt. And the statutory provision under which the Attorney General issued the subpoena plainly says that the subpoena has the force of law. So the Attorney General sort of waves his hands and say, this is just sort of a friendly letter to first choice. It doesn't have any legal relevance, and that's simply untrue. Moreover, that analysis is wholly irrelevant to the standing analysis. Even if the Attorney General were correct about self-executing, which he's not, what suffices for Article 3 standing purposes is that you have a present injury. The court has held over and over again that an objective chill is a present injury, and First Choice's associational interest, its relationship with those donors, are inherently chilled by this intrusive demand for their identities and contact information.
But in the absence of an order enforcing the subpoena, the Attorney General argues that the case simply is not ripe, and in fact prevailed at the lower court in the Third Circuit, albeit in an unpublished opinion. Why is that not right?
So two things. The state court, the state trial court, has actually enforced the subpoena. The state court found that the subpoena was valid and could go forward and held it enforceable, which is kind of inconvenient for the New Jersey Attorney General's argument. But in addition, I think a little bit of sort of procedural background would be helpful here. So when First Choice received that subpoena, it believed its constitutional protection applied to its donor information. So contacted ADF. We filed suit on behalf of First Choice in federal district court, alleging that the subpoena chilled these First Amendment rights. Well, the district court said, sorry, as you said, Professor Collette, it's not self-executing. It hasn't been enforced yet. You can figure this out in state court. In the meantime, the Attorney General had moved to enforce the subpoena in state court. But the problem with that first order and that has infected this entire case is that under Section 1983, everyone, including pregnancy centers, including the ACLU and the clients it represents, who actually filed an amicus brief in support of First Choice here, any person who is subjected to unconstitutional treatment by state officials gets to go to federal court. You don't have to wait for a state court to enforce a subpoena. That's simply not required under Section 1983. And the court's sort of best case for this is a takings case known as Nick. In Nick, the court overruled a prior case called Williamson County. And in Williamson County, the court had said, well, a takings claim, maybe it's not really complete until you haven't gotten compensation. So just for this class of claims, just for takings claims, you don't get to go to federal court. You don't get to avail yourself of Section 1983. You have to go to state court and have the state court see if you get compensation. But the problem with this, of course, is a doctrine known as preclusion. So in this case, in the Williamson County case, once these litigants get sent to state court, they stay there, because if the state court decides an issue, a federal court almost certainly cannot decide that same issue. So the lower court's opinions here really relegated First Choice and plaintiffs like it receiving these invasive subpoenas to state court forever, meaning that Section 1983 just doesn't exist for plaintiffs like First Choice.
Well, and that was observed in the dissent on an earlier Third Circuit opinion, I believe, as well, that the preclusion trap was something that, in particular, the New Jersey Attorney General had utilized in other unrelated, but nonetheless other cases involving constitutional rights. So what's the practical effect if if you're relegated to state court, and if the state court were to enforce a narrower subpoena, as I understand it, at least as argued by the Attorney General in his briefs to the U.S. Supreme Court, what would be sufficient evidence of chill that would get you the relief that you needed?
Sure. So a couple of things. You've mentioned the Attorney General is narrowing of a subpoena a couple of times. And I think it really is a clever litigation tactic. On the eve of the oral argument in the Third Circuit, the Attorney General sent a letter to First Choice and said, quote, at this time, the Attorney General was no longer seeking certain donor names and contact information. It was only seeking other donor contact information and names. And we think that doesn't moot the case for a variety of reasons. First, the Attorney General has never concretely disavowed. He still seeks some donor names, and he reserved the right to seek the donor names that he says he's narrowed the subpoena about. So he's still seeking that constitutionally protected information. And the court's cases are clear that federal courts are not required to allow defendants return to their old bad ways. When on the eve of litigation, a defendant, reforms his behavior, if that behavior can happen again, as the Attorney General expressly reserved the right to seek donor names again, all of the donor names. He's unconditionally seeking some even now, but he reserved the right to seek all that he initially had. The federal courts just don't let off defendants that easily.
And in this instance, the claim or the relevance of those donors' names to the Attorney General is to establish that these donors weren't defrauded. Is that his basic argument?
Yes, and he actually admitted in lower court pleadings, talk about a chill, that he wants to contact these donors. That this attorney general, who is overtly hostile to pro-life causes, wants to reach out and contact first choice donors, which of course inherently chills those relationships with first choice. As the donors attested to in a declaration, the possibility that their names might be disclosed to a hostile state official makes them less likely to want to contribute to first choice and organizations like it. The Supreme Court has been crystal clear that these associational rights are sort of the bedrock of the First Amendment. The ability to gather together is a precious and delicate freedom that allows us to exercise all of our other rights. And in cases like NAACP versus Alabama, to Americans for Prosperity just a few years ago, the court has held that these rights are so precious that even the possibility of a chilling effect on them is enough to advance on the merits of a case. But here, first choice wasn't even allowed to get into federal court at all.
Now, I noticed that this week the Solicitor General has requested to participate in oral argument in this case. And I believe you and your client have consented to that. Part of the argument the Solicitor General makes for allowing him to participate is that there are different standards in some states between the enforcement of subpoenas by the state courts and enforcement in federal courts. Is that something that I did not see that addressed in your cert petition, nor did I see it addressed in the briefing until the Solicitor General filed his request? Is that something that you anticipate the court will take up or consider?
I think they will, and the reason being is that there's a Supreme Court case called Reisman. It involved a lawsuit by tax attorneys who wanted to keep certain information privileged. And what the court said in Reisman was those attorneys who were subject to a federal court subpoena had an adequate remedy at law. They could challenge that federal subpoena issued by the IRS through an administrative proceeding. And this is really key. They could end up in federal court if they followed through with that administrative proceeding. That is precisely the opposite of what happens to a plaintiff like First Choice. If First Choice goes to state court and the state court decides those issues, then that means that federal court review of First Choice's associational and other First Amendment claims will never happen. So it's really key here when you're thinking about the court's equitable discretion, which is what was involved in Reisman, then an adequate remedy at law defeats equitable jurisdiction. So in that case, in the federal subpoena case, the later availability of federal review combined with the present availability of an adequate remedy sufficed. Here, of course, we have Section 1983, which says you get into federal court. We never get into federal court, unlike the Reisman's plaintiffs, if the Third Circuit is correct.
Well, and it's we're back to the preclusion problem.
Yes. Yes.
But B, it's my understanding that you filed in federal court before the Attorney General sought any sort of enforcement in the state court. Is that correct?
Absolutely, and that's a really important point here. There aren't any abstention doctrines at play. Younger and other doctrines might come into play if you had, a state court enforcement order or certainly a contempt order. But in this case, First Choice filed suit in federal court before the subpoena was due, precisely because it was suffering a present injury by the chilling of its First Amendment associational and speech rights.
Well, that's an important practice tip for those who are listening to our program to begin with. So in preparing this case, I noticed that there are several amicus briefs by organizations like the Beckett Fund and First Liberty and Thomas More Society and religiously affiliated special interest groups, if you will. Why is that? And are religious liberty questions interwoven? I didn't see them in the briefing initially.
So they're not presently interwoven in the jurisdictional inquiry. So we're not at the merits. We did raise a free exercise claim in the federal district court. But the issue before the Supreme Court here is sort of a procedural one. And that's where when you've alleged a objective chill to your First Amendment rights, whether you get to go into federal court under Section 1983 at all. But I think the reason that you have so many religious groups, and frankly, groups that ideologically are very diverse from them, FIRE that supports free speech rights, the ACLU, lots of folks, the Buckeye Institution filed suit to make the non-ideological point that where you have a state official that harasses and seeks constitutionally protected information, that state official needs to be held accountable in federal court. That's what Congress provided in Section 1983. So absolutely, if you look at the sort of harassment of pregnancy centers since the leak in Dobbs, they have been especially targeted. But this is a principle that applies to any civil rights plaintiff.
So in the real world, you lose. What's the harm beyond what's the strategy? What's the practice that you fear would develop if it's not already present in the areas of protection of human life, protection of religious liberty, protection of parental rights? What's the real world consequences if you lose?
Sure. So I think it means that for a certain class of plaintiff, you don't get to go to federal court. And that's a big deal. When Congress in Section 1983 provided a remedy for malfeasance by state and local officials, that means that every civil rights plaintiff gets to go to federal court. You can't carve off pregnancy centers or other organizations and say, as the court did in Williamson County, that we're just not going to hear certain sorts of constitutional claims or certain sorts of constitutional claims raised by certain plaintiffs. Congress said the exact opposite in Section 1983. It says any individual who is harmed by state action gets to file suit in federal court. And the practical reality why Congress did that, the Reconstruction Congress did that, it's the same reason we have diversity jurisdiction. When you have a plaintiff from one state and a defendant from another state, the founders thought that, and Congress, the first Congress thought that it made sense to have that heard in federal court in case you might have a home court advantage in state court. So the Reconstruction Congress and other Congresses have recognized that you might have a sort of a home field advantage in your own courts.
Well, and I think it's in your briefing, although it may have been in one of the amicus briefs. What I found to be a very simple and clear explanation to, particularly for folks that are listening that don't practice in this particular area, but just find the case intriguing, is that if the Third Circuit is correct, what we may have is authorization of hostile attorneys general doing all sorts of fishing expeditions that would not be permissible in federal court, that would not be permissible under federal law, and that would guarantee not only the imminent threat of harm, but the real harm having to occur before any remedy would arise. And if you're relegated only to state court, I know in Minnesota here, we had a period where there was what they called a Democratic trifecta, all three branches. And there was some legislation that was, well, basically they gutted any protection for pregnant women and unborn children in the state by virtue of that. And so I can see why that's a real concern, that hostile attorney generals in certain states will initiate almost immediately these sort of non-self-executing documents, but then they will be received sympathetically by the local courts that will exhibit the same sort of hostility to certain sort of civil rights that are important. So talk to me about some of the arguments that the Attorney General makes in the Supreme Court. He begins with this argument that, well, this isn't even a published opinion out of the Third Circuit, and therefore it violates the traditional rules about the kind of cases the Supreme Court takes. Now, I see nothing in the rules of the Supreme Court that says that it's a requirement that an opinion be published before the Supreme Court will take up the issue. But what's your response to that?
So I think it's a testament to how wrong the Third Circuit's decision is. I think the Attorney General is correct that as a practical matter, the Supreme Court doesn't usually grant cert from an unpublished two-paragraph opinion. But neither does the Supreme Court, and neither are the federal courts set up to make law good for one day and one case only. And I think what hopefully caught the court's attention here is that a federal civil rights plaintiff is being barred from federal court for a reason that doesn't relate to Article 3 standing. If you read the Third Circuit's opinion, it says, maybe it's not ripe. Maybe, you can still go to state court. We expect that you'll maybe get to federal court later, though it doesn't explain how that would be possible given preclusion principles. And so I think the Supreme Court really saw through the Third Circuit's decision here and said, despite that two-paragraph procurement opinion, this is an important issue, and every civil rights plaintiff, we hope the court will say, gets to use Section 1983.
The second argument, because as I recall, your reply brief actually cites fairly recent cases where the Supreme Court took up unpublished opinions. So I thought that was very well answered. The second argument they make is that there's really not a split in a circuit split. Now, again, my reading of the Supreme Court rules and the Supreme Court cases is while a circuit split certainly enhances your chances of getting cert granted, it is not a prerequisite. You could have a sufficiently horrendous case without a circuit split that the court, the case of the internment of the Japanese world, they took the case and it didn't get rightly decided. But nonetheless, I can think of an opinion that would be sufficiently bad that we're not going to wait for a split of the circuits in order for us to correct that. What is your response to the claim by the Attorney General that there's no circuit split?
Sure. So I think it's important to point out that those arguments were the brief in opposition stage. So they may be decent arguments as to why the court would consider granting cert or not. A circuit split usually is sort of an indicator that the court needs to get involved. But as you said, there are cases where the decision below is just wrong, and the court needs to review it. And once the court has granted review, then the presence or absence of a circuit split really doesn't matter to the merits. But as to the Attorney General's specific argument as to a circuit split, there's clearly a 1-1 split, a 1-2 now, I guess we can say. It's not super deep, but the Ninth Circuit and Fifth Circuit have disagreed. The Third Circuit, in its opinion below, appeared to join the Ninth Circuit or excuse me, the Fifth Circuit, in holding that even if you have a chill, so basic Article 3 principles, if you have a present injury, including an objective chill, then that satisfies Article 3 standing. But what the Fifth Circuit said, what the lower courts here said, is we're going to add something to that. We're going to say that, a chill is not enough. Instead, you have to have a state court enforcement order. But of course, then you probably never get into federal court at all, which brings us back full circle. The Ninth Circuit takes a different approach. The Ninth Circuit said that a First Amendment chill can indeed satisfy Article 3, and that's all you need. So those cases absolutely diverge. But the more, I think, important purpose or answer for present purposes is that under bedrock Article 3 principles, a present injury suffices. Courts don't get to add on to that.
And I noticed the way you carefully characterized the Third Circuit opinion, because as you noted, it's 2 paragraphs. So there's not a whole lot of, we join this circuit and we think their analysis is better than this circuit's. In fact, there's none of that in the opinion. Why do you interpret the Third Circuit as joining the Fifth Circuit on this?
For a couple of reasons. Several times it mentions ripeness first and foremost, and then it mentions several times that it expects the state court to be fair. It mentions the availability of state court review. And so the Third Circuit was clearly contemplating that in order to ripen the case, first choice needed to go back to state court. It also, frankly, upheld the lower court's decision that held the case was not ripe until it received an enforcement order on pain of contempt. But again, the lower courts don't get to engraft additional requirements, as the court has said over and over as of late. The federal courts have a virtually unflagging obligation to exercise the jurisdiction which they've been given. They don't get to carve out pregnancy care centers from Section 1983.
One of the listeners has asked a few years ago in Twitter versus Paxton, the Ninth Circuit dismissed as not ripe Twitter's effort to try to stop CIDs from the Texas AG. Is the case distinguishable, or is it just wrong?
So we actually agree with the legal reasoning put forth in Twitter. I think it's footnote 2, but in the Twitter case, the court says that an objective chill satisfies Article 3 and would make the case ripe. The court there just didn't think that Twitter had in fact alleged an objective chill. I think they called it bare factual allegations. Here, we of course have a lot more than bare factual allegations. When you were looking at the right of association, if you look at Americans for Prosperity, if you look at the NAACP case from the 1960s, 50s, you get the idea that this associational right is inherently infringed by a disclosure demand. And that makes complete sense. When you are a nonprofit association who is associating with donors who are contributing to your nonprofit, and their names, addresses, and phone numbers are requested by a hostile state attorney general so he can get into contact with them, that chills associational rights. So as the court said in Americans for Prosperity, that chill is reasonable. It gets you exacting scrutiny, and it certainly gets you into federal court. So short answer, we think that footnote, that reasoning is correct, but that here there is an objective chill.
What kind of facts would justify, given the hostility and your brief, I thought was extremely effective of evidencing the hostility, including graphic pictures of the various things and the conduct of the AG as a predicate. But what sort of facts, if any, in your opinion, would allow attorney generals, especially if they perhaps suspected money laundering through a charitable or 501c3, are there any facts that you think that chill would not be sufficient, or is that a merits question more than a standing question?
Absolutely, that's a merits question. So I think when you have the chill, you're entitled to get into Article 3, or you have satisfied Article 3, you're entitled to get into federal court. And then at that point, as the California Attorney General argued in Americans for Prosperity, maybe there are good reasons that you need particular donor names. Here, the Attorney General has never cited a single instance, a single complaint against first choice. So we don't think that would be at all satisfied, but it would be a merits question rather than a standing one.
And so at this point in time, have they set the argument date yet?
They have not. We believe it'll be in December, but it has not been set.
Okay. And are there continuing proceedings in the state court, or have those basically been stayed pending resolution of this?
Those have been stayed. The Attorney General agreed to stay state court enforcement proceedings during the pendency of the cert petition and then merits determinations by the Supreme Court. So those are not ongoing.
And have any discovery materials been provided to the Attorney General at this point?
Yes, First Choice has produced about, I think, 2,300 pages of materials documenting, the various things the Attorney General requested. Again, going back 10 years, really invasive demands from everything from training manuals to, again, the donor names. But First Choice has not provided those donor names or contact information. Instead, it objected that those were constitutionally protected.
Okay. And it was the training materials and some of the internal memos, as I recall, that organizations like Beckett, First Liberty, were saying raise not only the free speech, the chilling effect, free association, but also free exercise concerns because of the motivation, which you described earlier. At this point, we've answered the questions of folks that have provided. And so if you have questions and are listening, please let us know so that we can be sure and address them. So as you prepare for this, I'm sure you're going to do several moots. And then how long would you anticipate? Will this be one of the earlier decisions, since it is procedural in nature, that we can anticipate the court handing down, unlike some from last session that were the very last day that we were all waiting on?
So I think it depends. Like typically the more hot button issues do tend to be issued later in the term because the justices are really debating them, going back and forth on dissents and concurrences and majority opinions at the court. Here we hope we that it's always dangerous to predict the tea leaves, but we hope very much that the Supreme Court will agree, with amici on all sides of the ideological spectrum, that regardless of one's views on abortion, regardless of one's views on pregnancy centers, that when you have an objective chill of your First Amendment rights, you should be entitled to avail yourself of federal court under Section 1983. So we're hopeful that principle will not be controversial, but we shall see.
It does, except for the non-self-executing aspect, which you have suggested is largely a red herring in this context. It does seem to be a pretty clean procedural question with an answer of yes or no, and not a terribly complex question, although one should always be cautious about saying anything that's in front of the Supreme Court and characterizing it as not terribly complex. But
yes, and one thing just to pick up on the non-self-executing event. First Choice here received a subpoena. Someone from the Attorney General's office actually showed up at First Choice, requested to see Amy Huber, and handed her the subpoena that has the force of law, that says that she will be on pain of contempt if she doesn't produce all of this material. And it cites statutory provisions that allow for the imposition of penalties for the failure to, quote, obey the subpoena. So even if you think the subpoena is not self-executing, again, I don't, but even if you think it's not self-executing, receiving that sort of subpoena would objectively chill First Amendment rights of an organization like First Choice. So I really think that non-self-executing is simply legally irrelevant. The question is whether receiving this coercive government demand, did it reasonably chill First Choice's associational rights, regardless of whether it's self-executing or not? Was the chill reasonable? And I think it is. When you get a subpoena worded the way the New Jersey subpoena is, when it's backed up by the force of law. In another filing, in its state court contempt filing, to enforce, or excuse me, yes, state court action to enforce the subpoena, it actually said, the New Jersey Attorney General actually said that First Choice has already violated all of these statutes. So you've got this massive enforcement proceeding taking place against First Choice. So we think the chill is eminently reasonable.
Now, this litigation's been going on for 3 years?
2 years.
Okay. And this may be an improper question, in which case you can just frown at me and we'll move right on. But has your client seen a decline in contributions out of fear?
So the client has submitted a donor declaration, and those donor declarations do attest to that chill. Of course, standing is assessed at the time the complaint is filed.
Right.
But donors have attested that they will be less likely to donate because of the possibility that the Attorney General would get their names as a hostile state official. So, and again, cases from the NAACP all the way through Americans for Prosperity really hone in on both the importance of this First Amendment right to associate anonymously, as well as how sort of delicate those freedoms are. And in Bantam books, that the mere threat of hostility not backed up by coercion was enough for a First Amendment harm. So the court's cases have very much sided with the First Amendment in these sorts of cases, protecting it from harassment and abuse by state officials.
Well, and we know that historically, for example, any contribution would have consequences outside of the hostile Attorney General. I'm thinking in particular of the marriage fight, where you had the founder of a major computer programming company that was essentially ousted over his position and a donation that supported traditional marriage in California. California has been particularly active, it seems to me, in seeking donor information, and in that information then having all sorts of adverse consequences to those donors, independent of whether they're legal actions by the Attorney General or cultural actions or commercial actions by others, boycotts, etc. What have I not asked you that I should have asked you?
Oh goodness, I think you've covered it all really well. I guess one thing that's helpful to point out is that there are two main theories that First Choice is advocating for finding standing. We've talked a lot about the chilling factor under the First Amendment's associational protections. But of course, the Supreme Court also permits pre-enforcement review. And so we think that there's also Article 3 standing under cases like SBA list that say when you have a credible threat of enforcement, then that itself is a harm. That's actually what the Solicitor General of the United States brief focuses on, that there is a credible threat of a future harm, both the burdens of defending against that enforcement and the possible contempt and production of those protected documents. So really two different ways of getting to the same place.
Actually, that pre-enforcement challenge, I believe, was a doctrine that emerged in AOT versus Planned Parenthood versus AOT, and I was counsel at the lower courts in that, and the Solicitor General introduced the idea and the court accepted it. It's the only unanimous opinion on abortion from the United States Supreme Court ever. But it was this sort of procedural concern that they could unify on it to uphold the New Hampshire parental involvement law at that point in time. So, well, pending other questions, I would like to thank you very much, not only for the fact that you've been so clear and in explaining the position of your client and helping us understand to a large degree the arguments that are being made by the Attorney General in this case, but also the fact that Alliance Defending Freedom was willing to step up and help a nonprofit. My husband's been in the nonprofit arena for decades, and the sort of legal counsel that ADF provides is not the sort of legal counsel that any nonprofit really can afford. It's far superior. It's excellent. And so your client is lucky to have you. So with that, I will close, seeing no, oh, wait, we have one further question. Please provide contact information for Erin and Teresa Collette. I can be contacted through the University of St. Thomas in Minnesota, TSCOLLETT at stthomas.edu. Erin, are you in a position to provide some contact information?
Sure. You can just reach me at my email at adfehawley, HAWLEY, at adflegal.org.
And with that, we will thank our audience and thank the Federalist Society for giving us the forum to explain the case so that people can understand it more clearly. And I'll look forward to perhaps chatting again in December after the oral argument occurs, perhaps. Thank you, Erin.
Thank you.